The Supreme Court may have settled the pending case in Plateau State, but the conversation around the 11 national and state assembly members that were sacked by the appellate court's decision have raised questions about the competence of the judiciary. A panel of the Court of Appeal led by Justice Efriada Williams-Adaudu had in a unanimous decision in November 2023 ruled that Governor Caleb Mutfwang was not validly sponsored by the People's Democratic Party because the party had no structure in the state. The appellate court therefore nullified the election and declared the candidate of the All Progressive Congress APC, Dr. Nantwe Yaltwa, as the governor of the state. However, while the Supreme Court on Friday overturned the judgment on the governorship election and affirmed the victory of Governor Mutfwang, the sacked state and federal lawmakers cannot take the appeals to the Supreme Court based on the electoral laws which terminate the appeals at the Court of Appeal. Referring to the sacked lawmakers, Justice Iyan Okoro, who headed the Apex Court's 5-member panel in his consenting decision, said that his only worry is that people have suffered as a result of the Court of Appeal's decision that is absolutely wrong. So joining us on the morning show to discuss ways to rectify the Court of Appeal and the next action that the sacked lawmaker should take is Emeka Etiaba, Senior Advocate of Nigeria, who was the lead counsel of Governor Caleb Mutfwang. Welcome to the show. Great to have you back, sir, and I really appreciate you for taking our time to come to explaining all of this to us. I'd like to read two, case law citations for you. The first case law citation is on the jurisdiction of the Supreme Court over pre-election matter. The issue of substitution of candidates in the pre-Nigeria Weekly Law Reports 14 March 2011, Ucha versus Onwe 2011. That's NWLR 359 election matter. Although the election matter terminated at the Court of Appeal, matters relating to substitution, which is a pre-election matter, terminated at the Supreme Court, and the Supreme Court has jurisdiction to make pronouncements on such matters. Let's start with that case law I read as regards how can this debacle in Plateau be remedied. Have you tried taking a cursory look at that case law? And do you want to speak more as regards, how this can be remedied? Good morning to you, sir, and Happy New Year.
Rufai, Happy New Year. Ayo, Bimbai, Happy New Year. Viewers, Happy New Year. Thank you for the question. I'll start by saying that I was the lead counsel for the People's Democratic Party and not the governor himself, though we worked in tandem. We took the matter from the tribunal to the Court of Appeal and to the Supreme Court. And sadly, when the Court of Appeal overturned the judgment, very sound judgment of the tribunal, we had our worries. I personally, in an interview immediately after that judgment, did say that my heart bleeds for the National and State Assembly members whose elections and successes have been terminated. In fact, I used the phrase that they met their untimely death at the Court of Appeal because of the provisions of Section 2463 of the Constitution of the Federal Republic of Nigeria, which puts a ceiling on challenge of every return made with respect to State and National Assembly at the Court of Appeal. That is what it is. But in the case of the governor, I did mention that he had an option and an opportunity to get it right at the Supreme Court. And thank God for the Supreme Court justices who decided to do justice, not just in the case of Plateau State, but in all the judgments, 8 judgments that they delivered on Friday. Justice was met fully. In thanking the justices, I must also thank the President of Nigeria, who has allowed rule of law and has refused or has been seen not to have meddled with the work of the Supreme Court justices. I also praise the Chief Justice of Nigeria for allowing and encouraging his court to do justice. It takes all these people to make justice happen. I now go to your question as to the case of Ocha and Dome and what becomes of the faith of the National Assembly and State Assembly members whose elections were unduly and wrongly and erroneously upturned by the Court of Appeal. I must tell you that this is an issue that we have been trying to brainstorm to find solution to. Yes, a respected colleague of mine did commend the case of Ocha and Onwe as a solution. Incidentally, in that case, that was 2011. I was a counsel in that case. I represented the third and fourth respondents in that particular case. But that case, as much as it allows a case that relates to National Assembly to get to Supreme Court, if it is a pre-election matter, it may not be a wonderful authority for where we find ourselves. Reason being that, yes, the Supreme Court held that the case of the respondent, first and second respondents, are predicated on pre-election matters questions. But again, you know that Ocha and Onwe will only hold if a challenge of those judgments were brought within 60 days. Because at that time, there was no, there was no limit, a time limit for the challenge. In this, where we are now, you know, that judgment was delivered well over 60 days ago. So that window may have been short for the lawmakers. But of course, there is a good authority, but that time limit is an issue. I must also tell you that we've been thinking about the options, and we have not come up, we have not made up our minds. We'll make up our minds, and Nigerians will hear, the courts will hear. But as much as I personally think Ocha and Onwe will not be a good authority to rely on because of the time lag, I believe other options are available, and we'll look at them. And you know, in looking at the options that are available, one also has to make sure that a line is drawn between abuse of bringing an application, an appeal that will be an abuse of court process, and doing the right thing. So we're also looking at the options that are there. There are options. And like I will always say, ubi gis ibi remedium. Where there's an injury, there must be some way to rectify it, to assuage it. And we're looking for that remedy.
All right, talking about remedies to assuage and rectify what has been termed the appeal court's error of judgment. On announcement, the PDP had come out to say that they were looking to petition the NJC, which yesterday Mr. Wonikoko, who we had as a guest, had said, and a few other people had opined that it might not be the right line of action. Having been a part of, you know, the case, you represented the PDP. Was this from the PDP, and would that be one of the many lines of action that you would look to be taken? Not just because, you know, obviously the NJC cannot overturn a judgment from the appeal court, but also perhaps to check the judges or to petition the NJC with regards to the judges or justices who sat on the case. Would that be the reason why you're taking this line of action?
Okay, thank you very much. I am not aware of any petition. I'm not aware of it, so I can, you won't put it to me or ask me whether that is the reason why we are. I'm not in it. I'm not aware. My clients have not briefed me that they want to write a petition. But if I understand what my brother Wonikoko said, he was not against writing petition, but if the petition is geared towards bringing the lawmakers back, then it will be futile. Petition will only call to question the actions of the justices with a view to punishing them. It does not bring the legislators back to office. So to that extent, that's his argument, and that is very sound. A petition will not bring them back to office. And so we're looking at the actions that will bring them back to office, you know, not the one that will be punitive or administrative. And we're not ruling out the fact that they have a right, even as the victims, to petition. They have a right to petition. PDP has a right even if I, as a counsel, is not aware. My clients also reserve the right, because they are the greatest victim. All their legislators were swept away. Not one was left. In a case that was so straightforward, in a case that the justices were exposed to the authorities that we also quoted, cited at the Supreme Court and even at the tribunal, they just decided to do what they did. And you know, it is actually very sad, having followed this matter from the tribunal to the Court of Appeal to the Supreme Court. When we got to the Court of Appeal, we realized that a panel had been dedicated for Plateau State alone. That was against the policy of this present Court of Appeal. For all the election appeals that came up, as the appeals were ripe, the president created panels, instructed the justices that will handle them, and they went and handled them. So it became strange to us that a single panel could be created to handle all the appeals from one state. I don't think the court was charitable in that. And that is what has played out.
Right.
The first judgment came, it was in error, and then they continued along that line.
Right. Now, in the same breath, of course, they say the joy of a democracy is not about having winners or losers, but about having lawmakers that are democratically elected. In light of this, in light of your experience, now, what are the lessons? How do we manage this delicate balance where we know 95% of the elections in this 2023 cycle ended up in court? So how do we balance the mandate of democratically elected, fair and square elected officials and the intricacies of the court process? What are the lessons that you've taken away from this experience?
The lessons to be taken away is that Nigeria, as a democracy, pay less attention to the power of the electorate to elect who represents them. And with what has happened, no matter how wonderfully well INEC conducts an election, there will always be a petition. So there should be a way to sanction people who bring up petitions, frivolous petitions. There must be a way to do that. There must be a way to compel judges and justices to pay attention to settled authorities. Supreme Court has settled authorities in every aspect of our electoral jurisprudence. The court has set it out. All those cases are there. In the case of Court of Appeal, they were all cited, and they meant nothing. So number one is that we must find a way to make the votes of the people count. Number two is that we must find a way of getting the justices to answer to their wrongdoings, because it's a wrongdoing that a lawyer cites a Supreme Court authority to a Court of Appeal justice, and he ignores it and goes on his own tangent because he is my lord. That is very wrong, And we have to look at that desperation to be in the House of Assembly, to be at the National Assembly, to be at the presidency, be a governor. That desperation actually is because politicians know that there's a lot of money to make, not in terms of contribution to nationhood. There's a lot of money to be made. The other day we were talking about every National Assembly member going home with a Jeep that is worth about 165 million. Where do you get such money? Where do you earn it? So everybody tries by hook or by crook to get in. Now, again, with the judgments that the Supreme Court is churning out, it's now obvious to politicians that it is not business as usual. That is also a lesson. It should be a lesson that by the time you go to tribunal, you know that the courts will scrutinize what you're coming in with. It's not an issue of your lawyer being brilliant or knowing the judge. It is not about you having a deep pocket like in Plateau State where one ruffian, an idiot, was seen boasting. I saw it in the video. When we get to Supreme Court, we know who they know, and they know who we know. That man should be arrested. By now, he should be in Kirikiri prison. He is not supposed to be in any civilization, So these people are people who pollute the system. They tell you, just announce me winner, and they will know who we know, and we will know who they know. The man is on the street, and he's free. So we should begin to call to question actions of every stakeholder. We should be able to begin to sanction even lawyers who know the position of the law, but who prefer to canvass the other way. They should also be called to question.
Okay. That lawmaker that you were talking that said we'll know who they know is actually a lawmaker. And in fact, he was very, very vociferous. I think after leading up to the appeal court ruling of this case, and he defended his position, and he was triumphant. But I would also like to get him on to see his position now after the Supreme Court had decided. But let me ask you about something. And I know it's going to be a tough one I'll ask you. In all of this, you stated something very deep, that they specifically set aside a panel for Plateau. The president of the Court of Appeal, Monica Dokpa-Mensah, was seen, and a judge or a justice was seen defending, their rulings. And these were the reactions when people were saying all sorts about these rulings of the Court of Appeal. But they went on the defense. Number one, what's your reaction to that? It was a video of that regard, where they muted. And there was another video, I think, of another engagement of a justice in Nasarawa, trying to defend the judgments. What's your reaction to this?
You see that? My reaction is that it's a bad testament for Nigeria. Even the law school students know that when a matter is in court, it is sub judice. Nobody is supposed to comment on it. And so for a judge to deliver a judgment and go to the marketplace, the law week of the Adamawa lawyers, I can refer to it as a marketplace, the way we speak, And he goes there and begins to canvass in favor of a judgment that he delivered, and which is before the Supreme Court. That shows you where we are, But I will not say more because, my farm is the court. When we finish at Arise, tomorrow I'll appear before the Court of Appeal and Supreme Court and High Court. So let me leave it at that. But I can assure you that it's a bad one.
That's what I said. I know it's going to put you in a tough place, So, but another question I'd like to ask is this level of injustice that goes on in the country with the judiciary. You said something earlier on. You said after citing all of the cases, they chose to do what they did. Would you want to hazard, because we don't have empirical proof against our law justices, would you want to hazard that it was an oversight or it was a deliberate act?
Survive Rufai and survive any other journalist. I know where you're coming from, but the truth is that those authorities were cited and they thought little about them. I don't know what one can blame it to be. I don't know, but a justice of the Court of Appeal is tried and tested. But a justice of the Court of Appeal who decides to overlook an authority does it willfully. So I can assure you that they ignore those authorities willfully. You see, it is a funny one. Let me give you an example. At the tribunal, we led evidence to show that the court order was obeyed. After the tribunal, led by Honorable Justice Rita Irele Ifije and her team, after they went through our written addresses and the trial, they concluded two things. One is that the court does not have jurisdiction to try that petition, the petition having been predicated on nomination, invalid nomination, and sponsorship. But because they are a trial court, they are not the final court, they still had to make pronouncement on the substance of the of the petition, and they said that the court order was obeyed. They also found that Muthwang, His Excellency, was properly nominated and sponsored. You know, these are there, the authorities are there. We got to Court of Appeal, they assumed jurisdiction wrongly. And let me tell you, there are authorities, including Oni and Oyebanji, the current governor of Ekiti State, where the Supreme Court said that a political party whose leadership is in question does not lose the right to nominate and sponsor a candidate. I personally cited the authority in my brief. It is there. If the Supreme Court has said it, so be it. Even if you don't believe in it, you don't have a choice but to act on it. They said that the Congress was not properly conducted. Though that Congress was not challenged, it took place in 2021. No single soul challenged it in court until we brought up they brought up their petition in 2023. And for you to challenge any pre-election matter, you have to do it within 14 days, years after. Somebody who is not a member of the PDP, who does not have local standing, comes up to challenge it. And we orchestrated this, agitated the mind of the Court of Appeal, but they refused to agree with us, you know. And so we got to the Court of Appeal. They chose to assume jurisdiction, and they did what they did. Probably they didn't realize that Supreme Court will insist on their previous judgments, which obviously swept away whatever they thought was the true position of the law. It was so bad that in one of the judges at the Court of Appeal, one of the justices, referred to the finding of the tribunal. What he wrote was that the tribunal claimed, a judge is writing about a fellow judge. He said that the tribunal claimed that, started now saying what the tribunal held. Rather than say that the tribunal erroneously found or concluded, he said he claimed. How can a judge refer to the finding of a fellow judge as claim? That was where we are coming from. And thank God for the Supreme Court. I will quote Damian Dodo SAN again, who said, but for the Supreme Court. But for the Supreme Court, Kanu would have been boiling by now. Plateau will be boiling. Zamfara will continue to boil. And many others. But we thank God that Supreme Court got it right, and they will continue to get it right, we pray.
All right. So the Supreme Court got it right. However, the appeal court is said to have erred in judgment in some instances. We've talked a number of times, Mr. Etiaba, about the loss of confidence in the judiciary by Nigerians. And this incident in Plateau State does not, or perhaps I would say exacerbates that school of thought. Moving forward, how do we strengthen institutions, especially the institution of the judiciary and the legal system in Nigeria, which you belong to? Because it's come under a lot of question. I'm sure you'd remember the famous all eyes on the judiciary post-election. That's one thing, one aspect of what I'd like to ask you. And finally, it's this matter around elections being decided by courts. You yourself, following the last election, had granted an interview where you spoke about the fact that perhaps even in the way the elections were conducted by INEC and the announcement of those results, there were some areas that were open to some form of correction. Maybe there was some hastiness in the announcement of results. There were some red flags here and there with the way INEC conducted elections. Moving forward, we have an election this year in Edo State, and in 2027 we begin to run another cycle of elections. What can we do better? One, to strengthen the institution of the judiciary and, of course, the legal system as a whole in Nigeria. And then, of course, INEC as an institution. Very quickly, please, because of our time.
Okay. I can tell you that we are on the path of improving our electoral process. Because once the judiciary gets it well, I can tell you that 60% of the work is done. Supreme Court is leading the way, and I thank God that they are leading the way. Then INEC, as an institution, has to wake up, because a situation where INEC says one thing but does not live up to it, and then we hide under the cloak of, we are human, we have a discretion. That is not good enough. It is not good enough. And then one thing that is worrisome also is that in all the judgments, from the list of the offices to the presidency, no court vilified INEC for all they did at that election, not in any one. You know, INEC should be able to take some punches also, because in doing that, they now wake up and perform better, you know. Then we look at, we actually look at our laws and the body language of the judiciary. We say that election matters are sui generis. We use that sui generis anyhow. But the truth is that if we realize that election matters are sui generis, then we should be able to begin to say in every election petition, let's go for justice, not technicality. Let's go for justice. How do you explain that somebody who goes into an election and somebody wins the election with 400,000 votes, he scores 20-something thousand votes, and he wants to be pronounced by court as the winner of the election? Who is he coming to rule? You know? So, number one is to strengthen INEC. Already, INEC is strengthened, but INEC should strengthen themselves. Number two is that pressure that comes from incumbents. We are talking about Supreme Court having done well, because there's a president who has not come in to say, we must have it this way. And I can imagine the type of pressure the president went through. I'm not his fan, but I can imagine the type of pressure he went through when everybody in the party would want to acquire new states, Plateau State, Kano State, Zamfara, you know, as if we're heading to a one-party state. So kudos goes to him, but he has to do more. He has to do more. He has to make sure that these pressures do not continue to come to INEC and to the judiciary. We're talking about Edo State. You know, all those off-season elections do not receive as much pressure as the general election. You know, you can see what happened in Bayelsa. You can see what happened in Kogi. You can see what happened in Imo. I'm not saying that the elections were wonderfully conducted, but those pressures were not so much on INEC. You know, so we really have to make sure that these pressures are not brought to bear on INEC and judiciary. And again, for INEC, what prevents us from having all the elections in one day? Because what happens is that politicians, when you have two different dates, you do this one today, after 2 weeks you do the other set. They see their shortfall in the first election. They now go back and then begin to try to, you know, fill up the gaps.
Right.
Those are the things that those are the things we don't need.
Yes.
Let all the elections come in one day.
Right. On that profound note, Emeka Etiaba, Senior Advocate of Nigeria, thank you so much for your insight and for your knowledge today.